Welcome, everyone. We are grateful to be joined today by Professor John Hasnas. John Hasnas is a professor of business at Georgetown's McDonough School of Business and a professor of law by courtesy at Georgetown University Law Center. He's also the executive director of the Georgetown Institute for the Study of Markets and Ethics. His scholarship concerns ethics and white-collar crime, jurisprudence, and legal history. He's also one of the longest-serving summer seminar speakers, and his first summer seminar as faculty, I'm told, was also the first summer seminar at which Professor Jacob Levy attended as a student. So there's some nice continuity there. Professor Hasnas's lecture today, which is his first of two at the seminar, is titled "The Failure of the Market Failure Argument." And John, I'll hand it over to you.
Good afternoon. I'm happy that I can be here and do this for the IHS again. The lecture today is called "The Failure of the Market Failure Argument." My background is law and philosophy, so why would someone who's not an economist be talking about the market failure argument? I'll try to explain that. Some of the background is that when I began teaching many years ago at Georgetown's Business School, I constantly was exposed to arguments about the way the market failed and the need for regulation to correct for these market failures. And I was naive enough to not understand exactly what the argument meant. And when I asked for some clarification, my colleagues were willing to explain things to the new guy who was rather naive. And the argument goes like this. It starts off by recognizing that markets are great things because markets make the entire society better off. When two people trade with each other, each person gives up something that he or she values less for something else that he or she values more. And after the trade, both people have something that's more valuable to them than before they started. So after a market trade, both parties are better off, and in a sense, society is more wealthy. And that's why markets are great. Market trade produces gains, and that produces more prosperity and wealth. And that's usually the case, but there are some times in which that's not true. The cases in which it's not true are cases in which the parties to the transaction engage in activities that impose some costs on other people, and they don't take those costs into account. So for example, during the Industrial Revolution, if people figured out how to make linen shirts in a factory, then the public could get linen shirts, the buyer would get linen shirts at a lower price than they could otherwise obtain. That make them better off. The manufacturers would get money for the shirts, which is more valuable to them than the shirts. Both parties are better off. But the factories would use machinery that was driven by coal, and coal would burn. The soot from the coal ash would go up through the smoke. Cost to the market transaction that wasn't taken into account by the parties who were doing the bargaining. And that's usually, as I understand the argument, that's referred to as a social cost of the transaction. So sometimes market transactions impose costs on third parties that are not taken into account by the parties to the transaction. And these social costs reduce the overall value of the market activity. And there can be cases in which the social costs are so great that the social costs are larger than the benefits the the two parties to the transaction get from their exchange. And in that case, what happens is the market transactions actually make society worse off. They don't increase prosperity, they make things worse off. And in those cases, as I understood the argument, the market had failed to achieve its end, which was to increase prosperity. And when you have the market fail in that respect, what you need is something to come in and correct the market failure. That was the role of the government through regulation. Legislation could be passed which would prevent people from engaging in the kind of transaction imposed so much social cost on the rest of society that the costs to the third parties overwhelmed the benefit that the transactioning parties received. And so the argument was legislation is needed to correct for these kind of market failures because legislation can correct the market failure and therefore serve the public good in this way. So legislation was the remedy for market. I understood that there was a certain view of the way the market and the law worked that was underlying this argument. So I have a little picture that I think captures this. So this is what I call the relationship between law and the market. And I call it an academic conception because this was the idea that was explained to me when I was coming to understand the market failure argument. And it sees markets as the realm of unregulated voluntary transactions. And then what you need is the law. In some cases, you need the law to regulate voluntary transactions for the public good. And that's when the law will correct for the instances in which the market goes off course. Market transactions would not increase prosperity and be for the general welfare. So that's the kind of depiction that I saw. Now, before I go on and talk about this argument, I want to discuss something that's a complete digression. There's an experiment, a psychological experiment, which some of you may be aware of. It's often referred to as the invisible experiment. I'll describe that briefly to you. As some people watching a video in which two lines of individuals are passing a basketball back and forth between themselves, and they're moving around when they're doing it, and the instruction to the people viewing the video is to many times the basketball is passed back and forth between two teams. And they focus on that and they have to count this. And so it's not exactly simple. People are moving around. People are trying to count the number of passes. While this video is being shown, a person dressed in a gorilla suit comes walking through the video, stands for a moment, looks at the camera, and then walks on off. After the video is done, the people who are engaged in the activity are asked whether they saw the gorilla. And an amazingly large percentage of the people who are engaged in this say, "What gorilla?" They just didn't see it. The reason why it's called the invisible gorilla experiment is because even though the gorilla was right there in the middle of the video, the people who were viewing the activity didn't notice it. And the experiment is designed to bring out a characteristic that's called inattentional blindness. So it's inattentional blindness. And the idea of attentional blindness is that when your attention is intensely focused on one aspect of reality, you often can't see other aspects of reality which are otherwise perfectly obvious because you're just so focused on something. The reason why I'm bringing this up is because, to me, the market failure argument that I've described is a fairly good example of what I think it is intentional blindness. The argument makes sense to so many people. It makes sense to my colleagues. It makes sense to people who are in the academic world because they're so focused on a particular conception of the market and law. They're so focused on the model that's represented by the slide I have up now that they can't see anything else. And in fact, they can't see the most powerful regulatory force that's at work in our society. And that's the force I'm going to talk about today. That's tort law. To me, tort law and the market failure argument is the analog of the invisible gorilla in the psychological experiment. We don't see tort law because we're so focused on the political world, we can't see what's right in front of our face. Now, I'm not saying this because I don't mean to be condescending, and I'm not accusing anybody of blindness or anything like that. In fact, If you think the market failure argument made sense, if that you subscribe to that, I'm going to say your belief in that's not even your fault. If you're like me, if you were raised in the United States and went to public school in the United States, then you've been subjected to a lifetime of propaganda about what the law is. And in fact, I think I'll illustrate this with something that may be familiar to many of you, and that's this. See if I think a lot of you may recognize this.
I'm just a bill.
Woo, you sure gotta climb a lot of steps to get to this Capitol building here in Washington. Well, I wonder who that sad little scrap of paper is.
I'm just a bill, yes, I'm only a bill, and I'm sitting here on Capitol Hill. Well, it's a long, long journey to the capital city. It's a long, long wait while I'm sitting in committee, but I know I'll be a law someday. At least I hope and pray that I will, but today I am still just a bill.
Okay, I won't play too much more of that. But I suspect, although if I was in person, I'd be able to see you, but I suspect many of you recognize the video I just played. When you're in elementary school, this is the image of taught. That sometimes I say that if you go to public school like I did, you and I, we're all singing bill people, because we think that the law is something that's, if it's federal, starts in the House of Representatives, goes through Congress and is signed by the president, and that's our idea of what law is. Let me see if I can, there we go, back to that. What I want to suggest to you today is that this is a gross misrepresentation of both the law and the market. And I will try to quickly explain what I mean by that, and then come back to the market failure argument. So let me talk about the law first. Our legal system in the United States is part of the British Commonwealth legal system. It's part of the system that started in England and is the basic system for all of the British Commonwealth countries. And our legal system is often referred to as a common law system. But the law in the American system is composed of three different types of law. Legislation is one type, customary law is another type, and common law is another type. So quick definitions. Legislation, which is the type of law that's captured by the singing bill, by the Schoolhouse Rock video, that's law that's created by the actions of elected representatives. It's consciously created law that's made by politicians. Customary law, on the other hand, is law that arises from human interaction. If we engage in activities with others, we come to certain understandings about what kind of behavior is expected. And if we repeat the behavior often enough, eventually we get these customary rules that evolve. Common law is a particular type of customary law. Common law is the customary law of England as it was applied in the royal courts of England. As a matter of fact, almost all the law that undergirds our commercial society arose from the customary law, common law process. Property law, tort law, contract law, commercial law, even most of the substantive criminal law that we still live by, all arose through the customary law, common law process of evolution. None of this law is by legislation. It's not legislated. Shouldn't be misled by the term common law. Have heard the term common law, probably identify it with judge-made law, but that's not historically accurate. For most of history, the common law consisted of rules that were abstracted from a series of cases thought to represent just resolutions of past disputes. The idea of following precedent, of stare decisis that you hear a lot about, that's a very contemporary doctrine. That's only really gets started in the latter part of the 19th century. For most of the history of common law, the common law was simply rules that had been abstracted from many cases that people thought had good results, and so the rules were followed. William Blackstone, a commentator on the law of England, gave what is perhaps the classic definition of the common law. He called the common law, quote, general customs, which are the universal rule of the whole kingdom and form the common law in its stricter and more usual signification. So the common law is case-generated law or law that arises from the settlement of actual disputes. Now, the common law of England is interesting because our common law, it encompasses the customary law that predates the rise of the royal courts. It encompasses the customary law that had taught people how to live together peacefully and had evolved over centuries through human interaction. That's why the common law is called the customary law. And it's appropriate because much of English common law, especially tort law and commercial law, consists of the older customary law that's incorporated within it. Almost all of our commercial law was engrafted into the common law from the law merchant. The common law is a law that evolves over time from past experience. So in contrast to intentionally created legislation, legislation made by the conscious actions of politicians, the common law is, to use a phrase from Adam Ferguson, it's the result of human action, but it's not the execution of any human design. Tort law, which is what I want to talk about today, is the common law rules that govern personal injury. I teach torts at Georgetown. I teach an entire semester course in that. Nevertheless, I can sum up the essence of tort law in one sentence for you. Tort law is the law in which if one party acts in a way that imposes an unconsented to harm on a third party, another party, the injured party may bring a tort suit to recover damages or injunction to prevent the harmful activity, or both. The rules of tort law were not enacted by legislation. They evolved from the needs of ordinary people to live together in peace. I can't teach you the law of tort in the limited time that I have this afternoon, but I'll illustrate what I'm talking about with a couple of the oldest torts. And this is something I do with my class at Georgetown. Right. Two of the oldest torts are the tort of battery and assault. The tort of battery consists of the following. If a person intentionally causes a harmful contact with another person, or if a person intentionally causes an offensive contact with another person, that's a battery. Intentionally causing a harmful or offensive contact is a battery. Definition of assault is intentionally causing another party to apprehend that he or she is about to be battered, causing one to fear that they're about to be battered. So we talk about, the students learn assault and battery, and we talk about why these are the rules of law why are these the right rules of law? And my students, being products of the 21st century, come up with all kinds of brilliant ideas. They talk about individual rights, they talk about moral wrongdoing, but none of their explanations account for this. For instance, it's pretty easy to understand why a battery would be touching somebody in a harmful manner. But if you just come up to someone and sort of make a snide remark and flick their lapel, it's an offensive contact. That's a battery as well. Do you have a right not to be offended? Well, students usually think you have a right not to be hit. Do you have a right not to be offended? No, it doesn't seem to work out. Then there's assault. Assault is doing something that makes someone fear that they're about to be battered. So if I swing a baseball bat at someone's head from behind and miss, and that person's not aware of it, I have not committed an assault. I haven't committed a battery. In fact, I haven't done anything that constitutes a tort. So what can account for the rules of law evolving in this way? And the answer is they weren't planned by conscious human beings. They weren't created by people who are trying to achieve any particular end. They evolved through actual cases. If you go back to the time these torts were evolving, which is centuries ago, the most urgent need of society at that time was the need to reduce violence in society. There's no police forces. There's nothing like what we're used to today. In another context, I'll talk about the first government-sponsored police force doesn't come about until the 18th century in England. At the time that these torts are evolving, what people need is something that discourages the use of violence. So when people get into conflicts and bring them to members of society, which are the jury, to settle them, people often settle disputes by making decisions that will make it less likely people will do things that harm others. So if I strike someone in the face with my fist, that person's likely to fight back. Therefore, a battery would discourage that kind of activity. By the same token, if I just use lapel and call them a nasty name or cast aspersions on their parentage, and I'm very offensive, that tends to produce a violent response. So that needs to be discouraged also. And that's why battery discourages not just harmful contact, but offensive contact. With assault, if I do something, if I swing at someone and miss, that's going to cause them to fight back just as much as if I had hit him. So you need to discourage things that produce violence. On the other hand, if I take an action that the person's unaware of, there'll be no violent response. And so therefore, there was never a need to discourage that kind of action in order to prevent the violent conflicts. And the laws evolved in such a way that peace and didn't do anything else. So assault and battery are explanations of how the common law evolves. I won't go into this in greater detail, but assault and battery are, of course, only two of the intentional torts. There are many other torts that govern how we behave towards others. One of the important ones is negligence. What do we do when we've been careless and harmed someone else? The tort of negligence takes care of that. We have torts of trespass and nuisance. What about when our activities interfere with other people's enjoyment of their property? What happens then? Those torts take care of that. An important one, which I'll probably talk about at the end of this lecture, if there's time, is defamation. So when I say things that damage other people's reputation, how can we settle those kinds of disputes? Tort law is what governs all of this. None of it's legislated. Okay, so that's an account of the way the common law evolves. All right, let me stop. That's part of our law. That's a big part of our law. Having said that, of course, legislation is part of our law as well. That's the kind of law we're familiar with. Legislation is general rules that are created by political representatives that apply to all of the citizens in a jurisdiction. This is the kind of law that we've been raised to understand and to be most familiar with. And in fact, if you've been properly trained in public schools the way I was, then you understand why legislation is good, because you get the argument from democratic theory. Legislators represent the will of the public, and they can enact measures designed to achieve the public good in a way that the common law of tort or the common law can't. So their conscious planning allows the law to do things that will produce the good of society as a whole. And you're welcome to believe that. When you're in elementary school, when you're a kid, they say that, we believe it. You're welcome to believe it as well. There's a lot of reasons why you may not want to. I suspect some of the lectures that you'll get this week on economics or public choice will suggest why there's reason to be skeptical. Do legislators really act in the public good? I don't know, maybe you'll just examine the relationship between the current administration and the members of Congress and ask yourself how often the legislation that comes out of this process is really driven by considerations of what's in the common good and how much is driven by considerations of political considerations. If I was an economist, I could give you an entire lecture on public choice economics, which would cast some doubt on this, but I'm not. So instead, I'll just tell you one story that I think illustrates a reason why you can be skeptical of the value of legislation. I'm going to go back a couple of decades, but it's a good story, so it's worth it. When Bill Clinton was elected in Bill Clinton's first term, for the first 2 years, the Democrats controlled Congress. And the Senate Majority Leader was George Mitchell. He was a senator from Maine, and he was an interesting politician because he had a reputation for the highest integrity. Everybody respected him. Even though he'd been a politician his whole life, he was an extremely well-respected individual. In fact, to show you how good his reputation was, when he retired from the Senate, the first job he was offered was to be commissioner of Major League Baseball, because they wanted someone who had this kind of perfect reputation. Well, he did retire from the Senate in 1994 when the Republicans took over the Senate, and National Public Radio did an interview with him. They called it an exit interview with him when he was leaving the Senate. And I have a copy of this. One of the interviewers says to him, "You've been doing this job for so long, and there are all of these difficult personalities that you have to deal with. What makes the job of being the Senate Majority Leader worthwhile? What makes that worth doing?" And George Mitchell tells an interesting story. The story he tells is that the Clinton administration had a plan to cause the entire federal government to use only recycled paper, which apparently was going to be good for the environment and good for the entire country. Unfortunately, the paper mills where new papers manufactured are in Maine, which is the state that George Mitchell represented. And he said, because I had this position of authority, I was able to stop the Clinton administration from Bill Clinton from passing the executive order that would have required the federal government to use only recycled paper. And he tells the story that he's back in Maine giving a speech, and when the speech is over, this man comes rushing up to him. And at first his bodyguards were upset. Maybe this was somebody attacking him, but no, that wasn't it. The man comes up, he's got tears in his eyes, and he wants to thank George Mitchell for saving his job because he works in one of the paper mills. And George Mitchell says to the interviewer, "If that's what makes it all worthwhile, my ability to help people like that, and that's why the job is worth doing." George Mitchell was a politician known for his integrity and his honesty. I think we should believe him. The story he just told explains why political power and the ability to legislate is useful. It's because you have the ability to favor your parochial local interests over the good of society as a whole. You can stop something that's designed to achieve the common good in order to promote your particular interest, which is the interest of, in his case, the paper mills in Washington. So that's my story as to why you should be a little skeptical about the democratic theory behind legislation. I'm going to suggest to you that to correctly understand legislation, we should see it not as rules that are designed to regulate transactions in the interest of the public good. I'm going to suggest they're rules that reflect whatever the politically dominant interest is. So legislation is general rules that are passed by politicians that reflect whatever happens to be the politically dominant interest. That's my story about law. Let me take a moment and turn to the market, talk about the market. I consider myself libertarian. I consider myself a supporter of free markets. Having said that, it's my duty to explain to you that there is no such thing as the realm of unregulated voluntary transactions. That doesn't exist. There's no such thing as the realm of unregulated voluntary transactions. Human activity is always subject to some form of regulation. When we interact with other people, we're regulated by our ethical beliefs, or could be our religious training, whatever our ethical beliefs are, regulate how we behave with others. We are regulated by customary practices. My father was a small businessman. There were all of these customary practices that he had to subscribe to if he was going to do business with the others in his industry successfully, and that regulated his behavior. And then in addition to our ethical beliefs and customary practices, we're regulated by the common law, by civil liability, by the rules of tort law, which regulate how careful we have to be to avoid harming others. So we're regulated by all these things, and we're also regulated by legislation. So our activities are always subject to regulation in all of these forms. If that's true, what can it mean to talk about a free market? If there's no such thing as the realm of unregulated voluntary transactions, how should we understand the market? Well, I'll make a suggestion. I would say in the real world, when we talk about the market, we're talking about the realm of human interaction in the absence of centralized, coercive, let's say it's voluntary transactions that are not subject to political control or regulation by the government. That would mean that in the real world, we should understand markets as the realm of voluntary transactions that are regulated by ethics, by customary practices, by common law civil liability. That's the market. And it's a free market in the sense that it's free of political regulation, or it's free of regulation by the government. If I've done a good enough job of talking about what I think the law is and what I think the market is, then I can suggest that the relationship between the law and the market is different than what I've called the academic conception. So I'm going to suggest that this is a better way of understanding the relationship. And I've called it the real world conception. In the real world, the market is voluntary transactions that are regulated only by custom, ethics, and civil liability. In the real world, the law consists of legislation, because that's part of the law, which is regulation of voluntary transactions to serve the politically dominant interest, and common law civil liability. And in this depiction, you can see that they're not separate realms. The market and law interact, and there's a place where they are the same, and that's the realm of common law. So common law is essentially part of the market. It's a law that's part of the market. If this is a correct understanding of the relationship between law and the market, then I'll ask you to reconsider the market failure argument with this understanding. I say, note that civil liability can be thought of as the market's internal regulatory mechanism. I'll use an economic term here. In economic terms, the regulation of the common law of civil liability is endogenous to the market. It's built into the market. So a question we would want to ask is, how effective is this regulatory mechanism that's part of the market realm itself? So I have a few suggestions. I'll go back a couple of decades. In the election of 2000, Ed Nell was the chairman of the Democratic National Committee, and he was trying to raise money from plaintiffs' lawyers, which is a group that supports the Democrats to a great extent. And he did something that at the time was seen as a mistake. It's sometimes said that when politicians accidentally tell the truth in public, that's a mistake. But he was speaking to a group of trial lawyers, and what he said was, quote, 80 to 90% of the safety advances come from litigation, come from you guys. That the plaintiffs' lawyers, the tort bar, is what gives us most of our safety regulation, not the legislation. If you're familiar with any tort case, the one you probably heard about is the McDonald's coffee cup case. A little old lady spilled some coffee on herself and collected a lot of money. And that's supposed to be an example of why the tort system is so out of whack and ineffective. But the actual story there is that McDonald's had been serving coffee at 185 degrees Fahrenheit as a matter of corporate policy. There had been over 700 cases in which hot coffee had been spilled on customers who suffered serious burns. At that temperature, you can get third-degree burns if in between 2 and 7 seconds, which is so fast you can't even wipe it off before you're burned. If the coffee is served at 157 degrees, then it takes up to 60 seconds to cause that degree of injury. The company was well aware of this because they'd been sued 700 times, and they decided that it was worth it to keep on engaging in this dangerous activity. One little old lady served McDonald's who would have accepted compensatory damages, but McDonald's didn't settle. And that lawyer got to argue to the jury that this is an unreasonably unsafe practice. And what you should do is award this woman the amount of profits McDonald's makes in 2 days as punitive damages to send a signal to McDonald's that they need to turn the temperature down. The day after that case was decided, every fast food restaurant in the United States served its coffee at a safer temperature of 157 degrees. You may or may not think that's a good result. You may have all kinds of objections to that, but that to me is an example of amazingly effective safety regulation. In one day, everyone in the entire country was safe against burns from scalding hot coffee. Maybe that's too much regulation, but one thing's for sure, it's not too little. The fact that there's a tort reform movement out there is evidence of how effective tort law is at regulating the market. That's evidence that common law is the most powerful regulatory force we have. Think about plaintiffs' lawyers. Everyone hates plaintiffs' lawyers, but plaintiffs' lawyers give us an army of regulators. There's an army of safety regulators out there. They're looking for anything that's unsafe so that they can have a cause of action. Unlike state agencies, there's no limited budget. There's an unlimited number of these people. If any of you still watch broadcast television, every night they're trying to get you to sign up because you may have mesothelioma or something else, or you've used talcum powder. There's no public choice problems. There's no way the industry can capture these people. They keep on, they'll sue you no matter what. What are businesses more afraid of? A small fine from a regulatory agency, or the kind of bankruptcy that can come about from a large judgment? I'll illustrate this quickly with one story. There was another NPR story, was about a physician from Jamaica who came to the United States. He couldn't practice medicine right away. It took him about a year to get his license. He needed a job. So he got a job in New York City, and his job was to walk around the sidewalks of New York City. And wherever he found a dangerous place in the sidewalk, he made a little mark on a map, and he sent that into somebody. And he did that every week. Was he in the city of New York? Was he working for the political branches? No. He was paid to do this by a plaintiff's attorney who had people all over the city looking for dangerous places in the sidewalk. He would compile a map. He would send it into the city government and say, here's all the places that need repair. If you don't fix it, you're on notice that there's danger there. If anybody gets hurt, we can sue. We'll now go for punitive damages. Again, you may think that's terrible, but it's certainly not too little regulation, even if you think it's too much. That's where safety regulation comes from. Okay, if the problem with our current tort system is that it's too highly regulative, that it's too effective at internalizing social costs, then the market failure argument is obviously unsound. People who make the argument must be blind to what's right in front of their face, right? How can one both be in favor of tort reform and also make the market failure argument? It can't be that in the absence of government regulation, there's no regulation. If tort law is already too highly regulative. And this is why I regard tort law as the invisible gorilla. If you focus too much on the politics, if you focus too much on legislation, if you focus too much on the old academic model, on this view of what the law and the market is, then you can't see tort law. Tort law is the invisible gorilla. All right, I know you're gonna have questions and answers. Let me wrap this up and send you off to answer some questions. The market failure argument could be revised. If there are negative externalities, if there are social costs that aren't effectively internalized by the common law, by civil liability, then legislative regulation might be justified. If there are social costs or negative externalities that aren't captured in that green section of the diagram, that aren't captured by common law, now you might have an argument as to why you need the government to come in and regulate it. But my question to you will be, what are examples of this? What kind of things aren't captured by the common law? The question of how you regulate for safety is always a comparative one. One way of doing it is through civil liability and tort law. The other way is through government regulation, through the political means. It's always a comparative assessment. To structure your thinking a bit, here's the kind of steps you would have to go through if you want to use the legislative approach. If you want to use the legislative regulatory process, well, here's some of the things you'll do. You got to propose a bill. You have to deal with the bill's proponents and opponents. You set up the regulatory agency. You begin the rulemaking process. You deal with lobbying of regulated parties. You promulgate specific rules describing in detail what conduct of individuals you can engage in which they can't. You create the enforcement mechanism. You monitor the environment. You revise the rules. That's what you do if you go politically. If you want to regulate through the tort system, then here's what the rule is. Everyone's required to exercise the degree of care that a reasonable person would use to avoid causing harm to others by his or her actions. Which one of those mechanisms will be more effective? Okay, I think that I'm at 5:30, I think I'm required to stop and let you answer questions. I have a couple of more illustrations which may come up in the question and answers, but what I'll put to you all is to regulate the market. There's no such thing as an unregulated market. There's different ways of regulating a market. You can do it through ethics. You can do it through customary practices. We can do it through civil liability. That's part of the law. You can do it through legislation and regulation. That's part of the law. The question is always, which is more effective, civil liability or legislation? I've given you reason to believe that civil liability will handle perhaps most or maybe all of the regulation that we need. Is that right or wrong? Are there some things that can't be handled that way? What are the comparative assessments that you have to make when it comes to matters of regulation? Let me let you consider that for a while. And then when we reconvene, I'll try to answer your questions. And I will suggest at least one example of how powerful civil liability can be if you're really interested in doing justice.
So, Professor Hasnas, our first question was, how can torts be used for purposes of social justice?
It's a good question. I'm not sure my answer will be satisfactory because of the word social. All I know is how torts can be used for purposes of justice. I'll illustrate it. I had some additional slides I'll use to illustrate it, but I would talk about a time period in the 1950s, which in some ways is similar to what we're experiencing again today. But in the 1950s, that was the era of the communist scare and the blacklist, at which people could lose their livelihoods if they were associated with communism in any way. And there's examples of the Army McCarthy hearings. You've heard a lot about this. Let me give an illustration of what the government was doing at that time period. And I will share my screen again for a moment to do this. This is a publication of the House of Representatives from the late 1940s. It's the Committee on House Un-American Activities from the House of Representatives. It's 100 things you should know about communism. This is the kind of information that the government was publishing to the public at the time. So here's what's in the publication, information for the public. What is communism? A system by which one small group seeks to rule the world. Has any nation ever gone communist in a free election? No. How do communists get control? Legally, illegally, any way they can. Conspiracy is their basic method. Iron force is their method of communism. What would happen if communism should come into power in this country? Our capital would move from Washington to Moscow. Every man, woman, and child would come under communist discipline. How can a communist be identified? It's easy. Ask him to name 10 things wrong with the United States, then ask him to name 2 things wrong with Russia. His answers will show him up even to a child. How can a fellow traveler be identified? Apply the same test as above and watch him defend communism. How can a communist front be identified? Well, just call us, right here, write to us at this address and we'll let you know. 100 things you should know about communism and government. Yeah. Are communists traitors? This whole pamphlet is to help you make up your mind on that. The facts speak louder than words. Are communists loyal? To Stalin, not to the USA. This is what the government is publishing to the public. The important thing is they also publish another booklet, Guide to Subversive Organizations and Publications. This is an entire booklet of people and groups and organizations that the government is publishing so that people will know who to shun, who to boycott, try to make their life miserable. That's what the government's doing at the time. There were some people who were opposed to this. For those, I like to give movie references, which are usually out of date for the people I'm addressing. But in the early part of this century, there was a very interesting good movie called Good Night and Good Luck. It was the account of Edward R. Murrow, who tried to oppose McCarthy and bring to public what was going on. It's a wonderful movie, and people always think of Edward R. Murrow as a hero, but the movie's realistic. It acquaints people with the facts. And at the end of the movie, what happens is Murrow's show gets shut down because the government calls the head of CBS and says, we want this off, and it's suppressed. Not only is the government publishing this, it's able to suppress even CBS news shows. So what ended, this is my example of a real injustice. It's attacking people for their beliefs. What ended this injustice? And it obviously wasn't legislation. It wasn't the government. It wasn't political action. Two men ended this injustice. One was named John Henry Falk. One was named Louis Nizer. Louis Nizer was a tort attorney. He was a plaintiff's attorney. And John Henry Falk was a radio personality who had been blacklisted. He was sort of a Garrison Keillor-like personality. He'd been blacklisted and he decided to fight it in court. And he brought a defamation suit. And there's an account of this in Louis Nizer's book. So for those of you that are interested, this is the book I'm talking about. It's The Jury Returns. One of the chapters is called John Henry Falk, and it talks about the fight against the people who were running the blacklist. It took 2 years, and there was massive hardships, and there was all kinds of times in which this guy could have settled and gotten his job back and gotten some money. Stress on his family. The hardship that he went through is incredible, and he wouldn't settle because he wanted to right a wrong. And after 2 years, when this case came to court, and Louis Nizer and John Henry Falk presented what was going on with the blacklist to 12 ordinary citizens that were a jury, what came back, when the jury came back, they said something that seems very melodramatic. I won't waste your time with the video I had. The video was the last scene from a movie called The Verdict, which is supposed to be completely melodramatic, where a jury comes back and the judge says, have you reached a verdict? And the jury says, no, Your Honor, we have a question. What's the question? It's, are we allowed to award the plaintiff more money than he's asked for in his complaint? And that's what happened in the John Henry Falk case. 12 people came back, and after being acquainted with the blacklist, wanted to give the plaintiff more money than he was asking for. And that's what ended the blacklist. The next day, the blacklist was no more. That's the way civil liability, that's the way two men who are brave, that's the way tort law can be a force for justice. I don't know if it's a force for social justice. It's my best example of the force for justice. And if you are interested, get this book and read this chapter. It's a wonderful account of how you can use civil liability to fight for justice. All right, that was probably long-winded. Let me let you get to other questions while I figure out how to stop sharing the screen.
So continuing on the same theme, how would tort law address something like systemic racism? So specifically, why was something like the Civil Rights Act necessary for African Americans if they had a tort option available to them?
Okay, so there's two different questions there. One was about systemic racism, one was about the Civil Rights Act. Probably can't address both effectively in a short time. I don't know anything about systemic racism. I don't know what that means. I'm sure it exists. I have no solution for it. What's good about tort law is it doesn't deal with systemic issues. It deals with individual injustices. If you're someone who's been harmed as a result of another person's action, if you've been subjected to direct harm, physical harm, if you've been subjected to harm because someone's been careless, if you've been defamed, more than that, if there's been what's called tortious interference with your business judgments, if people are doing things that are trying to hurt you or make your life more uncomfortable, that's what tort law is for. If you're a Black person and you've suffered a wrong, can you bring a lawsuit? Yeah, you can deal with individual injustice through civil liability. Will civil liability right all wrongs? No. Will civil liability cure all injustice? No. You can't bring a lawsuit against somebody because they don't want to deal with you. You can't sue somebody because he's not hiring me or he doesn't want my business. You can't bring a lawsuit to do what the Civil Rights Act does, which is to make people deal with others whether they want to or not. So you can't get that out of the civil liability system. There's another question about whether you need that or not. Maybe there's an example, if you want to change people's hearts, then you have to go through the political mechanism, although I'm skeptical that the political mechanism will achieve the goals it's after. But as far as righting wrongs, the civil liability system is designed to correct harmful actions against individuals. It doesn't matter if you're Black or you're white or anything else, if the harm is directed at you because of racism, then you have a mechanism for getting into court. And the nice thing about civil liability is it's poor person's law, right? If you're the minority, how do you ever bring any kind of, it's almost impossible to move the government. And how do you get people to be on your side? But the civil liability, if plaintiffs' lawyers are out there looking for cases, they'll take your case on a contingency fee basis. Just turn on the TV at night, right? It used to be, if you have a phone, you have a lawyer. Well, phones are out of date now. So now the slogan is click through and you have a lawyer. If there's injustice going on, you can always get into court. And this is the way poor people get justice against rich people and corporations.
So is it the case that tort law can only regulate after a harm is occurred? So to go back to the McDonald's example, a lot of people got scalded before the famous case was successful. So is that a flaw of the tort system? Would a better designed regulatory system be able to address those harms before they reach the point where a tort case is successful?
That's an excellent question. Great question. I can answer it. The problem with having to switch to online from in person is we get less time. So I have to cut things out. Or so part of the thing that was cut out was about that. Right? The answer is no. It doesn't have to be always retroactive. Something I mentioned in the main talk, under civil liability, you can sue for damages or for something called an injunction. An injunction is something that stops people from engaging in an activity that could be harmful. So you can act prospectively, but there's different standards. To recover damages, you have to show that by a preponderance of the evidence that someone has done something that's caused you harm. That's a low standard. To get an injunction, which interferes with other people's freedom, there you have to show that there's a high likelihood of irreparable harm if people can engage in that. So to interfere with other people's freedom under the civil liability system, it's a higher standard. However, even that doesn't matter because legislation is always retroactive also. There's no difference. For example, let me see if I remember when the Patriot Act was passed. I think it was after 9/11. There's a law that some people have heard of, Megan's Law, that requires sex offenders to be registered. That's named after a girl named Mega Kenka, who was killed by an unregistered sex offender. Politicians don't know what's coming up. Legislation is always reaction to a harm that's already done. So is civil liability. Once there's a lawsuit and there's a decision, it works proactively. So as soon as you get a new rule, from there on in, you know what the rule is. But there's no difference between legislation and civil liability with regard to its proactive or retroactive measures. There says you're just more likely to get the result you want if you do it through individual action, then you have to go through the political process.
Okay, so we have time for one more question. Is it the case that common law will just necessarily evolve in a liberal direction, or are there areas of the common law that have moved in illiberal directions? And what's the relationship between these?
There's no necessary connection. There's no guarantee that the common law will move in a liberal direction. Fortunately, it usually does, but that's got nothing to do with political philosophy. It's got nothing to do with ideal justice. I mean, I'm a libertarian. I might hold these things. That's got nothing to do with common law. The reason why the common law tends to move in a liberal direction is because the way it works is by composing disputes. When people get into conflicts, they need something that stops them from fighting. And the common law finds something that restores peaceful relationships. It finds a way in which people can cooperate. And it just so happens that one way to get people to cooperate is build fences. Property rights do a pretty good job of getting people to cooperate. So that's the way it comes out. The common law doesn't give you a perfect, like libertarian system where there's all kinds of definite rights. I've got other talks on that. It just makes it more likely that it just gives you peaceful relationships. It gives you cooperation. And cooperation is the path to prosperity. It's the path to more freedom and more liberty. It's not a necessary connection. It's a contingent connection. It can change. I mean, if we really do a good job of raising the next generation to be people who don't care about liberty and just want to be safe all the time and are completely infantilized, then when they make the decisions in juries, that's the direction the common law will go in. However, for the last 500 years or so, it's been moving in a liberal direction, and I think there's reason to believe it will continue in that direction.